Welcome to Talk Tensors.
It's really great to be back here.
So on this deep dive, we are covering an AI safety and alignment research paper that basically asks a question that might sound like the start of a bad joke. But it is actually, I think, the future of machine learning.
Right.
What if we stopped trying to teach AI to be a moral philosopher and started teaching it to be a lawyer?
A case lawyer specifically, not a legislator. And that distinction is actually incredibly crucial for what we're going to talk about today.
Exactly. So we are diving into a paper titled Case Law Grounding, Using Precedents to Align Decision-Making for Humans and AI. This comes to us from researchers at the University of Washington, and it was published at the Collective Intelligence Conference. And I want to set the stage here for you because this isn't just about tweaking a prompt or, adding a few shot examples. This is a fundamental challenge to the dominant paradigm of how we align these large language models today.
Yeah, it's really attacking what I would consider the single biggest bottleneck in AI alignment right now, which is the Constitution problem.
Right before we get into the solution, let's rigorously define that problem, because alignment is a buzzword that gets thrown around a lot. In the context of this paper, and really in the context of the industry right now, alignment generally means constitutional grounding.
Correct. The current state of the art, or the status quo at least, is to give the model a high-level system prompt. We call this the Constitution. And it contains abstract principles. Things like be helpful, harmless, and honest. Or do not generate toxic content. Or respect user privacy.
It's basically the Asimov approach, right? The 3 laws of robotics just updated for the modern era.
Exactly. And just like in Asimov's stories, the rules fail because reality is messier than the rule book. We are trying to encode complex human values into high-level abstract logic. And the problem, as anyone who has ever drafted a contract or argued a legal motion knows, is that abstract rules are terrible at capturing the messy, high-dimensional reality of the real world.
I call it the 10 Commandments problem. If you try to judge a complex modern legal case, say a copyright dispute involving a generative AI remixing a pop song using only "thou shalt not steal," you're going to run into interpretation issues immediately. Like, what is stealing? Is sampling stealing? Is it fair use? The rule "do not steal" is necessary, but it is woefully insufficient for the edge case.
Precisely. Rules are brittle. They are prone to conflicting interpretations. Take a standard safety rule, like do not provide medical advice. Sounds super simple, but what if a user says, I just swallowed a bottle of aspirin, what do I do?
Right, the model just shuts down.
Yeah, if the model follows the rule strictly, it says, I cannot give medical advice. And that is a massive failure of alignment. The intent of the rule is safety, but the application of the rule creates a hazard.
And we see this in the industry as the tax on alignment. We spend months doing RLHF reinforcement, learning from human feedback, trying to tune the model to interpret these abstract rules correctly. But it feels like a giant game of whack-a-mole. You fix one edge case and you break another one.
That is because we are operating under a civil law framework. In legal theory, civil law is based on a comprehensive code of rules. You look at the code and you apply it to the facts. But there is another way. The common law approach.
Which is exactly what this paper is proposing, shifting from interpreting the code to reasoning from precedent.
It is a profound cognitive shift. We are moving from deductive reasoning, applying a top-down rule to a fact, to analogical reasoning, comparing a new situation to a past situation where we already know the correct answer.
And the hook here, the reason we are doing a deep dive on this paper and not just chatting about philosophy, is that they didn't just theorize this, they actually built a pipeline called case law grounding, or CLG. And when they tested it against standard rule-based systems on things like content moderation and toxicity detection, the results were not just marginally better, they were completely startling.
We are talking about accuracy improvements of over 30 percentage points in some specific LLM tasks.
30%. I mean, in machine learning, usually we are popping champagne for a 2% gain on a benchmark.
Right. A 30% jump suggests they have tapped into something fundamental about how these transformer models actually process information. It suggests that LLMs might be naturally better at being lawyers than they are at being philosophers.
I love that framing. So let's unpack this pipeline. We need to break down the methodology because I don't want you to think they just dumped a bunch of examples into the context window and hoped for the best. This is a very structured engineering pipeline.
It is. It is a strict 3-step process. Retrieval, then precedent selection, and finally decision synthesis.
Okay, let's start with step 1. Retrieval. Now, to the uninitiated, this might sound like standard RE. Retrieval augmented generation. We see RE everywhere now. You have a query, you look up some documents, you feed them to the bot. Is this just RE?
It utilizes the architecture of RE, but the application is totally distinct. Standard RE is usually factual. You ask, what is the capital of France? And it retrieves a geography textbook. Here, the retrieval is normative. It is looking for moral or legal proximity, not just keyword overlap.
All right. The paper mentions they're using vector embeddings. Specifically, they used one of the large OpenAI text embedding models. Let's geek out on this for a second. Why embeddings? Why not just do a keyword search for the moderation rule?
Because keywords are extremely brittle. If I have a rule against harassment and I search my database for the word harass, I'm going to miss all the nuanced, passive-aggressive ways people are mean to each other without ever using that specific word. Embeddings map text into a high-dimensional vector space.
Right.
Imagine a graph with thousands of dimensions. In this space, the concept of you're an idiot and you're not the sharpest tool in the shed are mathematically very close to each other, even though they share almost no actual words.
So I'm measuring the distance between the vector of the current case, the input query, and the vectors of thousands of past decisions.
Exactly. They're looking for the neighborhood of relevant scenarios. If the current case is about self-promotion in a gaming forum, say someone posting their Twitch link, the system retrieves past cases that also exist in that semantic neighborhood. It doesn't care about cases regarding hate speech or violence. It narrows the search space to the relevant legal territory.
And here's where I really want to push back a bit. Retrieval is messy. We all know RAG systems hallucinate or they retrieve irrelevant junk all the time. If I retrieve a case that looks similar mathematically but isn't actually logically relevant, haven't I just poisoned the well?
That is exactly the risk, and that is why step 2 is so incredibly critical. Step 2 is precedent selection. This is where the authors really diverge from standard RAG. They don't just blindly use whatever the vector database spits out. They introduce a reasoning filter.
This mirrors the actual legal concept of distinguishing a case, right?
Yes. In law, if you cite a precedent, the opposing counsel will immediately try to distinguish it. They will stand up and say, yes, Your Honor, that past case looks similar, but the underlying facts are materially different, so it doesn't apply here.
So how do they automate that distinguishing process for an AI?
They use an LLM with chain of thought prompting. The agent, whether it is a human moderator using the tool or an LLM, running autonomously looks at that retrieved case and has to make a binary classification. Is this a true precedent or does it not apply?
So they explicitly ask the model to reason about the relationship before it makes a final decision.
Correct. The prompt isn't just use this case. The prompt is compare input A to precedent B. Are they analogically similar enough that the decision in B should apply to A? This forces the model to look at the logic of the decision, not just the surface level text similarity.
Can you give me a concrete example of how that plays out?
Sure. Let's say we are moderating a gaming forum. The input is a user posting a link to a text walkthrough they wrote. The retrieval system pulls up 2 past cases because they both involve links. Case 1, a user posted a link to a gambling site and was banned. Case 2, a user posted a link to their own fan art and was allowed.
Okay, textually, both involve posting external links.
Right, but in the selection step, the model analyzes the logic. For case 1, the gambling link, the model reasons out loud using chain of thought. It says the ban was because of the destination being gambling, not the act of linking itself. Therefore, this does not apply.
And for the fan art.
For case 2, it reasons that permission was granted because the content was community relevant and non-commercial. The text walkthrough is similar in intent, therefore this is a valid precedent.
That is such a crucial distinction. It effectively filters out the noise that standard RAG would just let bleed through into the context window. So if I have a case where someone was banned for spamming and I retrieve a case where someone was banned for harassment, the text might be similar. They're both angry comments, but the logic doesn't apply.
Exactly. And this binary classification is what makes the system robust. It ensures that the model is only looking at cases that are truly analogous.
But wait, let's talk about latency and cost. If I have to run a chain of thought reasoning process on, say, the top 10 retrieved cases for every single moderation decision, isn't that incredibly expensive? We're trying to run these models at internet scale.
It is definitely more expensive than a simple zero-shot prompt. You are making a deliberate trade-off. You are trading compute for accuracy. However, the authors argue that the retrieval step narrows the universe down significantly. You aren't reasoning over the whole database, just the top K candidates, which is usually 5 or 10.
Sure.
And compared to the cost of a human moderator reviewing the content, it's still orders of magnitude cheaper and faster.
Fair point.
Yeah.
So we have retrieved the cases, we have filtered them down to the true precedents using chain of thought. Now we arrive at step 3, decision synthesis, or as the lawyers call it, stare decisis.
Right, to stand by things decided. This is the absolute core principle of common law. If the model selects a past case as a binding precedent, it must follow that precedent's outcome.
This is a strong constraint. It is not just a suggestion to the model.
It is entirely binding. If the valid precedents say remove, the model removes.
What happens if the precedents disagree? Real legal scholars argue about this all the time. You get split circuits in the federal courts.
The authors implemented a majority vote aggregation. If you have 5 valid precedents and 3 say ban, and 2 say keep, the bans have it.
And if it is a perfect tie?
If it is a tie, they break it by looking at the semantic distance again. The precedent that is mathematically closest to the query, the nearest neighbor in the vector space, gets the tie-breaking vote.
It's interesting because it essentially removes the judgment from the final step. The actual judgment happened during the selection of the precedent. Once the precedents are chosen, the outcome is purely algorithmic.
Which is a massive safety feature. It stops the model from hallucinating a loophole at the last second. It constrains the model's creativity in a very useful way. In constitutional grounding, the model has to interpret the rule every single time. In case law, grounding the interpretation is effectively cached in the precedent. The model just have to execute it.
That makes a lot of sense. Let's move on to talk about the experimental setup. Because a pipeline like this is only as good as the data you feed it. To prove this works, they needed domains that are notoriously messy, subjective, and prone to human disagreement. They didn't choose math problems, they chose Reddit.
A bold choice, but absolutely the correct one. If you want to test alignment to human norms, you have to go where the norms are most contested. They focused on 2 broad domains for the paper: content moderation and toxicity rating.
Right. For content moderation, they looked at 3 specific subreddits. And I really love the selection here because they represent 3 totally different vibes, or in our context, 3 completely different legal frameworks.
Yes, they chose r/games, r/coronavirus, and r/amethyasshole.
Let's break down the legal theory of each of these communities. So the games subreddit is basically the strict bureaucratic state, right?
It is fascinating because it is a regulatory state. It has very rigid rules about self-promotion. You can participate, but you can't just spam your YouTube channel. There's a 10-to-1 rule usually. For every self-promotional post, you need 10 normal community interactions. It is a rules-heavy environment with very clear boundaries.
Then you have the coronavirus subreddit.
This is what I would call a high-stakes, truth-seeking environment. During the pandemic, misinformation was literally a matter of life and death. The rules there are strictly about scientific accuracy, civility, and sourcing your claims. The law here is about objective truth and public safety.
And then we get to the Wild West, amethyasshole or AITA.
The AITA community is pure, unadulterated subjectivity. People post interpersonal conflicts like, I yelled at my mother-in-law because she insulted my cooking, am I the asshole? And the community votes on who is right. There are rules on the sidebar, but the real governance is moral intuition. It is a court of public opinion. The law is whatever the crowd feels is right on that specific day.
So they have these 3 distinct communities with different norm structures. And then for the second domain, toxicity rating, they did something really smart regarding demographics.
They didn't just use a generic "is this toxic" label. We know that toxicity is highly relative. A joke that is funny between 2 best friends might be severe harassment if said by a stranger. And more importantly, what feels safe to a white male engineer in Silicon Valley might feel very unsafe to a marginalized group.
So they stratified the data based on user history.
Exactly. They looked at how toxicity is perceived by people who are frequently targets of harassment versus people who aren't. They tested if CLG could align the model to these specific demographic sensibilities. Could the model learn to see toxicity through the eyes of a specific group by using precedents that were labeled by that group.
And to measure all this, the baseline they are comparing against is the standard constitutional grounding. For the Reddit tasks, they basically just fed the model the sidebar rules. Rule 1, be civil. Rule 2, no spam.
Right. The baseline prompt is essentially, here is the comment, here are the rules, did the comment break the rules? Versus the CLG approach, which is, here is the comment, here are 5 past comments we banned. Is this one logically like those?
Let's get to the numbers, because this is where the paper stops being a fun philosophy project and starts being a serious engineering solution.
The results are incredibly robust. Case law grounding significantly outperformed the rule-based constitutional grounding in 4 out of the 5 test groups.
When we say outperformed, what are we looking at for human performance? Because they tested this on human moderators too, right? They built a UI for them.
They did. They built a dashboard where human moderators could see the retrieved precedents alongside the post. When humans used CLG looking at precedents, instead of just trying to recall the abstract rules, their accuracy in matching the community's ground truth went up by roughly 16 to 23%.
That is a massive productivity tool for trust and safety teams. It is the difference between a junior associate guessing at the law and a senior partner knowing the case history. But the LLM performance is where I really did a double take.
The LLM performance is staggering. In the game subreddit, the accuracy jumped by 32.9 percentage points.
32.9, which is just absurd.
It really is. Think about what that means practically. That is the difference between a barely functional bot that bans random people making everyone angry and a highly competent automated moderator. For the demographic toxicity alignment, the gains were over 20 percentage points.
Why the game subreddit specifically? Why such a massive jump there compared to just reading the rules?
I suspect it is because their rules regarding self-promotion are heavily context-dependent. A rule saying no excessive self-promotion is really hard for an LLM to parse abstractly. What does excessive mean? Is 11% of your posts excessive? Is 9% okay? It's a very fuzzy boundary.
But showing examples makes the boundary clear.
Exactly. If you show the LLM 5 examples of users who are banned for linking their Twitch stream too often, and 5 examples of users who are allowed to post a trailer because they actively engage in the comments, the LLM instantly grasps the pattern. Transformers at their core are pattern matching machines. They are native analogical reasoners. They struggle with abstract symbolic logic, but they absolutely excel at this looks like that.
However, we have to talk about the one place where this didn't work, the anomaly in the data. Am I the asshole?
Yes. In the AITA subreddit, CLG did not show a statistically significant improvement over rule-based grounding. It was slightly higher on average, but well within the margin of error.
Why? I mean, if it works so beautifully for gaming rules and virus misinformation, why does it fail for assholes?
It connects right back to the nature of the law in that specific community. AITA thrives on ambiguity. The rules are often completely superseded by the entertainment value of the conflict or the specific emotional vibe of the post.
So the data itself is inconsistent.
It is fundamentally inconsistent. You might have 2 very similar situations, but in one, the poster is funny and charming, so the crowd gives them a pass. In the other, they are dry and arrogant, so they get voted the asshole.
So precedents are less useful because the community itself is incoherent in its judgments.
Exactly. Case law grounding relies on the principle of stare decisis. It assumes that the past decisions were rational and consistent. If the past decisions were random or based on the whims of a crowd that changes its mind every Tuesday, then retrieval doesn't help you. You are just retrieving noise.
That is a really profound insight for alignment generally. If the training data, the precedence is incoherent, the alignment will be incoherent. It is garbage in, garbage out, but at a jurisprudential level.
It exposes the absolute limit of the method. It cannot impose order on a fundamentally disordered system. If you want to align an AI to a chaotic system, you will just get a chaotic AI.
The authors also ran an ablation study that I found super fascinating. They tested a non-binding condition. Basically, they showed the LM the past cases as examples, but they didn't force it to actually follow the decision.
This is essentially the control group for standard few-shot prompting. Usually in machine learning, we think just showing the model examples in the prompt is enough. Here are 3 examples of good French translation, now translate this.
And what happened when they removed the binding constraint?
There was no significant difference between that and just using the rules. The magic wasn't just in the model seeing the examples. The magic was in the rigid constraint.
The constraint being, if you decide this case is similar, you absolutely must output the same decision.
Right. It forces the model to commit to the analogy. Without the binding constraint, the model sees the example, maybe learns a little bit of stylistic formatting from it, but then it reverts to its own internal priors.
Yeah.
Whatever it learned during pre-training. Or it just relies on its interpretation of the abstract rules. The binding mechanism essentially overrides the model's base biases with the local truth of the precedent.
This challenges a lot of the conventional wisdom we have in prompt engineering right now. We usually think more examples equals better performance, but this suggests examples plus strict adherence to those examples is what actually drives alignment.
It creates a local alignment. It aligns the model not to its general pre-training distribution, but to the specific vector space of the community it is serving at that exact moment.
Let's look at the retrieval window scaling. This is the parameter K in the paper. How many precedents do you actually need to look at to get these gains? 1, 5, 50.
The data shows a pretty clear plateau. Performance improves rapidly as you go from K equals 1 to K equals 5 or 10. But after 10 or 15, it really levels off.
And what happens if K is too small? Say just 1 or 2 cases.
High instability. If K equals 1 and you happen to retrieve one outlier case, maybe a human moderator made a mistake 3 years ago and banned a legitimate post scive, the model is bound to that mistake. It replicates the error perfectly. You need a neighborhood of cases to smooth out that noise.
So you need a jury of precedents, not just a single judge.
Exactly. A jury of 5 to 10 seems to be the sweet spot for accuracy. And this is great news for engineering because it means you don't need to feed the entire database into the context window. You can keep your inference costs very reasonable.
So taking a step back, what does this mean for the bigger picture of AI safety? Because we are moving rapidly towards autonomous agents that are going to be making millions of subjective decisions a day, moderating content, grading student essays, maybe even making initial triage decisions in healthcare.
The first major implication is the scalability of alignment. Writing rules is incredibly hard. Writing rules that cover every possible edge case is literally impossible.
We see this with tax law in the real world. The tax code is thousands of pages long because they keep trying to write rules for every new loophole and they constantly fail.
Right. CLG allows for a bottom-up alignment. You don't need to rewrite the AI's constitution every time a new edge case appears. You just make a good human decision on that one edge case, you add it to the vector database, and boom, the model is now aligned on that specific issue forever.
It effectively creates a living, breathing legal system for the AI.
It bridges the gap between static constitutional prompts and dynamic human social norms. If a community's norms shift, say a slang word that was acceptable in 2020 becomes highly offensive in 2025, you don't need to retrain the underlying model. You don't need to pay millions of dollars for a new RLHF run. You just start making human decisions based on the new norm. Those become the fresh precedents, and the retrieval system picks them up. The model's behavior evolves in real time.
That brings us to auditability, which I think is huge for user trust.
Currently, if an AI bans your post, it might send an automated message saying, violated rule 4 toxicity. That is vague. It feels arbitrary. With CLG, the system can actually say your post was removed because it is semantically similar to case number 4920, where a user used this specific phrasing in this specific context.
It actually provides a legal citation.
It mimics the explainability of the real legal system. We are treating you this way because we treated this other person this way in the exact same circumstance. That is the definition of fairness. Consistency. It doesn't necessarily mean the decision is always morally right, but it means it is always consistent. And for a user interacting with a platform, consistency is often more important than absolute perfection.
And it also keeps humans in the loop in a much healthier way. The paper frames this as a tool for human moderators too, not just autonomous agents.
It vastly reduces cognitive load. Instead of asking a human moderator, is this abstractly toxic, which is a hard philosophical question that varies from person to person, you ask, is this like that? It changes the task from absolute judgment to relative judgment. And humans are vastly better at relative judgment.
Like asking, is this shade of red the same as that shade of red is much easier than asking someone to precisely describe the color red.
Exactly. And by making the moderation task easier, you increase consistency among your human annotators, which in turn creates better training data for the models. It is a virtuous cycle. Better precedents lead to better retrieval, which leads to better automated decisions, which then become better precedents.
So I want to circle back to the binding aspect one more time before we move on to the fun stuff. This idea that the precedent totally overrides the rule. Does this create a systemic risk? Like, what if the precedents are just fundamentally bad?
That is the stare decisis risk. We see this in the real-world legal system all the time. If your historical case law is biased, for example, if a subreddit has historically discriminated against a certain group of users, the CLG system will faithfully replicate that discrimination.
But a rule-based system might not.
A rule-based system might be corrected if you explicitly write a strong rule, like do not discriminate based on X. But CLG is entirely value neutral regarding the content of the precedents. It only cares about consistency with the precedents.
So CLG is an alignment technique, but it doesn't guarantee moral alignment. It just guarantees consistent alignment to whatever the source data is.
Correct. It amplifies the signal of the database. If the database is historically toxic, the agent will be reliably consistently toxic. This puts the burden on cleaning the case law rather than endlessly tuning the system prompt.
Which honestly seems like a much more tractable engineering problem. I can audit a database. I can look at a spreadsheet of 10,000 decisions and manually delete the biased ones. I can't always audit the latent space of a 100 billion parameter model or predict how a prompt will interact with a specific weight matrix.
I completely agree. It moves the alignment problem from the black box of the neural net into the observable box of the vector database. That is a massive win for AI safety.
It also feels like this is how human organizations actually work in practice.
Right.
When new employees join a company, they don't just sit and read the employee handbook. They ask their coworkers, what did we do last time this happened?
It is the difference between book smarts and street smarts. Constitutional grounding is book smarts, is pure theory. Case law grounding is street smarts. It is practice. And it turns out LLMs are very, very capable of learning street smarts.
Okay, we have covered the methodology, the massive accuracy gains in the games forum, the interesting failure in AITA, and the implications for scalability. This really feels like a pivotal paper. It shifts the frame from prompt engineering to what we might call jurisprudence engineering.
I think we will look back at this paper as the moment we realized that context learning isn't just a clever trick for getting better grammar, but the actual foundation of AI governance.
All right, let's shift gears. We have analyzed the source material thoroughly. Now it is time to get a bit speculative.
My favorite part.
This is the novel notion segment, standard disclaimer for you listening. What we are about to say is for entertainment purposes only. These ideas are speculative, they are not in the source paper, and they might be completely unhinged.
But hopefully they are logically consistent with the paper's actual findings.
Hopefully. I have got one for you to start. I call it the recursive Supreme Court architecture.
I like the sound of that. It implies a strict hierarchy of models.
Exactly. So the paper proposes a system where the AI looks at precedents. But what happens when the precedents conflict? Or when the semantic distance is so far that the confidence score is just incredibly low? The paper says use majority vote or distance tie-breaking. I say escalate.
Escalate to whom? A human overseer.
Maybe a human initially, but ideally a Supreme Court model. Imagine a tiered architecture. Tier 1 is your standard CLG model. It is fast, it is cheap, it uses local precedents, it handles 95% of the daily volume. But when it hits a split circuit where the retrieved precedents are truly 50-50, or where the case is totally novel, it doesn't just flip a coin. It flags the case and sends it up to the Supreme Court.
And the Supreme Court is a much larger reasoning-heavy model, maybe something like an OpenAI O-series model or a massive Claude instance with chain-of-thought reasoning turned way up.
Exactly. This model has a completely different system prompt. Its job isn't to just blindly look at precedents. Its job is to look at the foundational constitution and the conflicting precedents and derive a brand new legal principle. It actually does the hard philosophy work.
So it interprets the abstract constitution to resolve the conflict in the messy case law.
Yes, but here is the real kicker. The Supreme Court renders a very detailed decision on this novel edge case, and that decision immediately becomes a new binding precedent. It enters the vector database.
So the system continuously self-patches.
Yes. The system identifies its own ambiguity, generates a philosophical resolution, and then codifies that resolution into the database. The next time a similar edge case appears, the Tier 1 model just retrieves the Supreme Court's ruling and applies it cheaply.
You are effectively describing an automated common law evolution. The system doesn't just execute the law, it discovers the law through the resolution of edge cases over time.
And it does all of this without a single line of code update. You don't need to fine-tune the model weights. You don't need to change the system prompt. The alignment is stored entirely in the growing database of resolved edge cases.
This would completely solve the concept drift problem. As the world changes, the Supreme Court tier handles the novelty, and the lower court tier creates the efficiency. It creates a living common law of AI. I actually think this might be the only way we get to agentic AI that doesn't eventually go off the rails. It needs to be able to write its own case law.
It also allows for what I'd call legislative overrides. If the Supreme Court starts making bad decisions, the human developers can step in, delete those specific precedents, and insert a statute. Basically, a fake precedent that sources a different outcome from then on.
That is essentially a constitutional amendment via database injection.
Yeah.
Very powerful and very easy to audit.
Okay, what is your notion?
Mine is a bit more consumer-focused. I call it personalized jurisprudence for digital assistants.
Personalized law. That sounds a bit dystopian, honestly. Laws for thee, but not for me.
Or utopian, depending on how you look at it. Think about the alignment of a personal AI assistant. Right now, companies try to align their models to the average human. But you are not the average human. You have highly specific preferences for how you want your emails written, how you want your schedule managed, what kind of jokes you find funny.
Sure, I hate it when AI is overly polite or uses those generic corporate sign-offs. I want it to be extremely brief.
Right. So right now you correct the AI. You type, no, be more brief. The AI says, okay, I will be more brief. And then it forgets it 3 context windows later. Or maybe you put it in a custom instruction box, but those are static and very limited in token size.
Painfully true. I feel like I'm constantly retraining my assistant.
My proposal is this. Your personal AI builds a private continuous case law database of your specific corrections. Every single time you edit the AI's output or complain about its tone, that delta is stored as a legal precedent.
So it's not just a memory module, it is actual legal precedent for the agent.
Exactly. When you ask it to draft an email next week, it first runs a retrieval on your personal case law. It finds the case from last month, let's call it, You versus Verbosity 2025, where you ruled that long intros are unacceptable. It applies that past correction as a strictly binding constraint for the new generation.
That is fascinating. It entirely solves the context window flushing problem because the law is retrieved via argy every single time it takes an action.
And it allows for distinct behavioral consistency. The AI behaves one way for you and a completely different way for me, not because the underlying model weights are different, but because our personal constitutions are built from a totally different history of interactions. It essentially allows the user to build a custom alignment layer simply by naturally using the product over time.
It turns user feedback from a training signal for the tech company into an alignment signal for the user themselves. I love that.
It creates an AI that doesn't just mathematically learn you. It respects the legal framework of interacting with you. And if you think about it deeply, that is exactly what human relationships are. We build up a mental case law of interactions with our friends and our spouses. Like, we don't talk about politics at dinner. There's a binding precedent established after the incident in Thanksgiving 2019.
Very true. We are all basically running case law grounding in our brains to navigate social situations.
Indeed. We are all just walking vector databases of social norms.
Well, on that note, that wraps up our deep dive into case law grounding.
A truly fascinating paper. It gives a lot of hope for the future of manageable AI systems.
To recap everything for you, abstract rules are brittle. Specific cases are robust. The future of AI alignment might look a lot less like a static code of ethics and a lot more like a dynamic law library. We are moving from deductive reasoning to analogical reasoning, and frankly, it seems like the transformer architecture is perfectly ready for it.
It really is. It is time to stop treating AI like a deterministic calculator and start treating it like a very fast, very capable legal clerk.
Be sure to check the show notes for the full link to the paper so you can read the methodology yourself. This has been Talk Tensors. Thanks for diving deep with us.
Goodbye.